Number 55, the people of the state of New York versus Derrick Ulett.
Thank you. Thanks.
Good afternoon. May it please the court, Layla Hull of Appellate Advocates for Mr. Ulett. May I reserve 2 minutes for rebuttal?
You may. Ms. Hull, in this case, why isn't the testimony of 3 eyewitnesses, 2 of whom knew the defendant and 1 who picked him out of a lineup, why isn't that enough to overcome the failure to disclose the video?
One of the witnesses that you mentioned didn't see the shooting. That witness becomes a potentially exculpatory witness once you get to view the video and the defense has an opportunity to interpret it and present it to the jury. The second witness, who is a stranger identification, did not have a meaningful opportunity to see the shooter. She saw the side and back view of somebody for a split second or 2 seconds while she was actually looking at the gun and running away. That's her testimony. And the final witness, who is the people's real central witness in this case, presented several red flags. He didn't come forward for 10 months and only did so when he was motivated to seek a benefit. And he did get, while there's no formal cooperation agreement, and we do understand that, he did get quite a generous plea deal. And while that information may have been in front of the jury, what was not in front of the jury was a recording of a shooting progress that lay bare a series of events that was different than what their central witness testified to, and also showed that there was potentially a different shooter. And that, in a case like this, where you've got 3 witnesses, as you have presented them, Your Honor, you need this kind of evidence to penetrate that kind of a case. Otherwise, all you're doing is sort of playing around on the periphery and pointing out here and here and here. This type of video evidence is crucial in a case like this, and that's why it's unquestionably material. And it would have reframed the entire course of the defense, and also most likely—
Because it would have supported a theory that someone else is the shooter?
Yes, it also would have given additional avenues of investigation, a new eyewitness, and even if they could not find that witness, which we strongly dispute in our brief as not being possible, we think it very much could be possible, they could also point out the fact that that witness exists and the people haven't presented them, especially when their other eyewitness, the stranger identification, is such a poor one in terms of a lack of a meaningful opportunity.
Is there any view of that video that makes Cream something other than an eyewitness?
I'm sorry, I don't understand the question. It raises some serious questions about whether or not he's telling the truth. To what extent does he have an involvement in this case? I mean, he does avoid the police at the time of the shooting. He goes inside. He tells somebody that the victim has been shot, but he then, kind of sneaks out of the building.
But that's all in evidence.
That's all in evidence, but what's not in evidence is a video that says, that shows why he might have not been telling the truth, something that is concrete.
So that's how you're going to use the video to impeach Cream?
Yes, that in addition to when he's asked, are there other people there before the shooting, 12 minutes before the shooting, he says, no, I don't remember, and no. And that, it's
to show there are more lies and or to show that perhaps he's the shooter? Is that what you mean?
Either one. You could show more lies. You could show that he's potentially involved. He may have a reason to be concerned, but you also don't need to necessarily ascribe a clear motive to Cream. You just need to demonstrate that he isn't telling the truth. And as the 440 court found, this tape could have done that. But it parsed the materiality of each aspect of this video. And instead of considering them in their totality, as the Supreme Court requires in Kyle's, it simply said, here I don't agree, here I don't agree, and here I don't agree. And that's the same analysis the people are advancing as well. And I also think what is critical here is the prosecutor's summation. If this wasn't material, then I don't know why the prosecutor would have falsely denied to the jury that it existed. So clearly the NYPD thought it was important. They collected it. They made made stills of this video. They gave those stills to the prosecutor, and the prosecutor had them in her trial file along with stills from a video they did put into evidence. And to the extent that the people are also arguing that the video doesn't show, as much as we claim it is, that, first of all, is belied by the actual 440 record here.
Your argument doesn't depend on bad faith by the prosecutor, is that right?
No, because there's no bad faith exception to Brady, and there's also no bad faith exception to a summation misconduct, but it is the reality of it is that the statement in summation was not correct. And that was what the jury believed. The jury believed there was no documentary evidence capable of challenging the people's case.
And we've said that statements like that, misstatements, can enhance the prejudice to the defendant in the materiality analysis, right?
Yes, and with good reason. And the concern here is that you've got a case where it looks deceptively stronger than it is, and the suppressed video of the shooting in progress really lays bare that it could be a house of cards. And that's what the jury should have been considering. The jury should have been debating what's on that video. Is it the people's theory or is it the defense theory? But they never got a chance to do that, and they were told it didn't exist. That in its totality really requires reversal and a new trial in this case. Mr. Ulett is doing 25 to life in a case where the jury didn't actually get to consider all of the relevant evidence.
Because the potential shooter, or as you argue it, that one might view on this video, is running in a different direction.
Yes, that's
And
exactly.
that's what it all turns on, yeah?
Yes.
Yes.
Yes,
So-
the alternative shooter.
Right, so Cream
theory-
could have been wrong about the direction they're running in,
I don't believe
or
believe
anyone
he's-
else could have been wrong about the direction they're running in.
I believe Cream said he went in the direction he came. So no. So I actually think it contradicts directly Cream's testimony if the shooter is going.
I'm sorry, I thought that's what I said.
Oh, I
That it would-
apologize.
That it would say it's not going in the direction, the person's not running in the direction Cream said he was running.
I get confused by double negatives. I apologize. Yes, exactly. Yes. But
In some ways, it seems like we have to determine whether the correct test was applied by the trial court in the 440 court in evaluating the evidence. The way I understand it is he ruled that if the defense had the tape, the jury would have returned a verdict that was more favorable to the defendant. And our test may be something different, which is that there's a probability sufficient, if it had been turned over, to undermine our confidence in the outcome of the trial. And it's really which test we're applying here, isn't it?
yes, and I think, the second one is the test that the Supreme Court has laid out and
So you're
explained.
saying that's the test, and the test is not whether or not the jury would have returned a verdict that was more favorable to the defendant.
That's Kyle's said.
So, okay, so
Yes.
tell me, what's the
Sorry.
difference between undermining the confidence of our confidence of a verdict, in a verdict, and a verdict that's more favorable, returning a verdict more favorable to the defendant?
Where I think the suppressed evidence would have reframed what the trial was really about.
You mean by impeaching Cream, who was one of the main identifiers? here?
Impeaching Cream, providing an alternate theory of who the shooter was,
Well, it could have also identified a possible witness, too.
and yes, exactly.
Yeah, I see, okay.
So if I, may I?
Yeah, go ahead.
So
No, to me, that's the nub of the case. How do we apply this test?
Absolutely. This case is about what the test of materiality is and how does it apply to these facts. I completely agree. And in this case, what it does is it means that the jury would have been asking a whole host of different questions and would have been judging the people's evidence against a recording, an objective piece of medical evidence, also being able to consider the ballistics evidence in a completely new light. All of that would have meant that the deliberations most likely would have been different. The complexion of the case would have changed. That is why you can't feel
Do you
confident.
need most likely would have been different?
Excuse me?
Do you need the deliberations most likely would have been different, and what do you mean by that?
No, I don't mean that most likely the outcome would be different. That's not what I meant to say. I apologize. What
No,
I mean
just
is
trying to
that
clear
the
it up.
questions that most likely would have been raised in the case would have been different. Because everything that we are debating,
The
you know,
potential view of the evidence.
potential view of the evidence, and I think this case, the litigation on appeal is illustrative of this. We would have all been, everything that the prosecutor and I are arguing about would have been the trial. That would have been what everyone was debating. But the fact finder should have been the jury. And as much as I am very happy to be here, the fact finder should be the jury on what the outcome of this debate would be.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. I'm Ruth Ross for the Brooklyn DA's office for the respondent. There was no Brady violation in this case because the inadvertently undisclosed, low-resolution, overexposed surveillance video was not material.
You're not challenging the first two prongs of the Brady analysis, right? That this was impeachment at the least, and that it wasn't disclosed. So all we're arguing about here is
The only issue in front of Your Honors is the materiality. And this is not simply a three-witness case. This is three independent witnesses. One who actually saw the shooting and who knew the victim and the defendant for his entire life. And not only that, Cream says, I was friends with the defendant till the moment he shot Rubin.
And the argument is that the video is additional evidence to undermine the veracity and reliability of this witness. So what are the other two witnesses?
And so we're not just talking about Mr. Cream because
We have Bazemore and Courtney.
we have a completely disinterested witness, Coretta Bazemore, who also saw the shooting and identified the defendant from a photo array 5 hours after the shooting.
And then
She
testifies,
coincidentally happened to identify the same person
And then
that Cream
testifies,
did?
excuse me a second,
Sorry.
and then testifies at
Yeah.
trial that she may have been wrong about her identification, no?
She was, I think, not willing to contradict the attorney, but then she said on redirect, could have been, but I don't think so. And we have her testimony that she was at most 3 car lengths away, that she saw him, that she identified the gun, she described the same outfit, she had him all in black, sort of tallish. But not just that, we have a third witness who also knew the defendant for his whole life, who is completely unrelated.
Didn't see the shooting.
He didn't see the shooting, but he saw the defendant come down the street from his apartment building.
Defendant lives in the neighborhood. What's unusual about that?
Yes, he turned the corner, he heard the shots, and then he saw the defendant fleeing, tucking something into his waistband. Mr. Courtney, who is that third witness, not an eyewitness to the shooting,
But why
it's
excuse me,
circumstantial.
but why is counsel wrong? Given that's testimony, that the jury, with the defense attorney having this video available, having the opportunity to show this to the jury, to be able to make these arguments, try and undermine Cream further, why isn't she correct that that might have made the jury, or all you need is one, juror, perhaps look at that evidence differently? And that was not available because they didn't have this video.
The only question that we have is, is it material? Is there a reasonable probability, not possibility, but probability that there would have been a different outcome? And
That's really the question. Is that the test, or is it the test that it undermines our confidence in the verdict?
well, that's part of the definition. And the reasonable probability of a different outcome, is it sufficient to undermine the confidence?
The problem is you have, well, on its face, it does look like a strong case, but then you don't have any physical or forensic evidence. You've got 2 of the eyewitnesses who had credibility or reliability problems, and the tape appears to clearly create impeachment evidence for the one witness, Cream, who was standing right there when allegedly the shot took place. So somebody is either mistaken or they lied. One of those two things happened. So let me just finish my point.
Okay.
So that being the case, how do I not say, well, I can't be confident that this result was beyond a reasonable doubt?
Because the 3 witnesses are not looked at in this case separately, but as they corroborate each other. You have Coretta Bazemore, who is identifying the same individual as Ray Shaw Cream.
What about the existence of the delivery man, the person bringing in? And I blew up the pictures themselves. I could make out his face on those in the video, and I have it with me today. I blew it up and looked at it, and it seems to me that if you were really concerned, a good attorney would go throughout the apartment building and see if anybody could identify this person who clearly was an eyewitness to the shooting.
Well, first, there are three burdens that the defendant has to overcome. First of all, you have to first of all, he would have to locate this individual.
Oh,
It was
there's no question, but.
17 months after the shooting is when
No
defendant
question about
is.
that, but we're assuming a number of things. You can assume it's the delivery man. It could also be the grandson of someone who lives in the building.
Exactly.
Right. Easily identifiable. Listen,
the other
isn't
thing
there
is-
one, the people did actually disclose this tape, though, didn't they? What do you say about that? That they mentioned it in DD5 number 13, the surveillance video.
Absolutely.
Uh-huh.
And not only
Is that, would
Sorry.
you characterize that as a document dump, or was it made clear what it was, or was it just the existence of it?
No, it was clearly, it states, DD5 number 13 states that surveillance video was recovered from 48 St. Paul's Place, from the lobby of 48
How do you
St.
then
Paul's
square that
Place.
with the prosecutor in summation saying it doesn't exist?
She doesn't say it doesn't exist, Your Honor, if I might contradict you slightly there. She is responding to a defense summation in which defense counsel has argued that you've heard there's video, why haven't you seen it? She made an implied missing witness argument about, well, it must have shown something helpful, or the people would have shown it to you.
So why isn't the correct response, we identified it to her, she knows there's video, and here's the form on which we showed it to her, and we gave that to her months ago?
As the court below held, the prosecutor forgot. She said that she had,
Well, it's one thing to forget, it's another to say, I'm quoting, and isn't it common sense that you would have seen that video if there had been a video?
Right.
That's not forgetting, that's,
next
excuse me.
I'm sorry.
I'm making a representation to this jury, as you say, in response to defense counsel's summation.
but the next sentence, Your Honor, is there's no, you've heard, there's no video. You haven't heard anything about a video outside. Yes, there's a video inside. So she is qualifying it with the next sentence. If you take that first sentence out of context, it sounds much more blanket statement that there is no
Problem is,
video.
you're sort of trying to have it both ways. You're saying we can charge the defense with knowledge because this showed up on a form, and we can excuse the prosecutor for saying in summation that it doesn't exist, even though it was on a form. And
Well,
that does
it-
seem inconsistent.
It wasn't just on the form. It was, she elicited testimony from Angela Davis, who said, oh, yeah, there's absolutely a surveillance video camera in the lobby there.
But
the
doesn't, counsel,
video-
doesn't that go back to my original question? Is you're not contesting that this was impeachment or other material that should have been disclosed and you didn't disclose it.
Right.
My view of the DD5 is only it gets you the standard of reasonable probability rather than reasonable possibility because they knew that it was around and they never specifically asked for it. So you've gotten a benefit of that already. The rest, it doesn't really matter that you disclose the DD5 because you didn't disclose the tape.
Right.
And you had an obligation to, and we're by that. And I think
Yes, you're
the
right.
problem here for me that I'm having is the nature of your case, and you had significant proof in the form of eyewitnesses, no forensic evidence tying this defendant directly to the crime, as Judge Fahey points out. But balanced against that, you don't have, a prior statement that you find in the file that may contradict some things the witness said. You have a video of the crime scene. And in fact, in this video, you have the defendant falling from being shot. And the defense is saying we could have used that in a number of ways in this trial, including impeaching your witness, finding witnesses, having a different theory of the case. That's a pretty powerful argument for me, compounded by, I think, a fair reading of the prosecutor's summation, which is if there was a tape, if it existed, you would have seen it. So I think that's a fairly tough hill to climb for the prosecution.
Well, it's not as though this was an actual video of the shooting. You don't see the shooter. You don't see the gun
We
fired.
have the case Virouette, you know Virouette, right? And where we say Virouette's destroyed evidence, but we say, look, this was the same type of video. It was a video of a crime scene. It didn't show the shooter, but it showed who was coming in, who was going out, who was present. And that's material in the case of, a destroyed evidence issue. But how can you say, again, we don't have the shooting, but we have the scene, we have coming and goings, we have people coming in and out of the building, potential witnesses, we have Cream, I think, coming into the building afterwards. All those things were subject to fairly extensive cross. People's movements, who was there, when they were there. And the nature of a videotape showing the crime scene at the time of the crime, not the shooter,
Right, and I would
could have
also...
been used in all those ways. So
I would point out that although perhaps Your Honor has been able to make out the face of the putative bicycle delivery man, the other shapes are absolutely spectral. You cannot tell who's there, you can't tell who's coming or going, and the fact is that you have 3 witnesses who say the shooter...
You turn that video over, you don't know what kind of defense investigative services they could have engaged to either enhance that image or
But that
whatever.
enters into the realm of speculative.
That's really not up for you to decide. The point is to turn over the tape and let them do what they can with it.
Yes, that's absolutely the case, and it's the policy of our office in anything that's the least bit questionable to turn it over. But mistakes do get made, and in this case, there was an error.
So it's
It
an
wasn't...
So you're
Inadvertent
saying this was a
mistake.
mistake, not a
No,
conscious
it was-
choice? I thought the prosecutor said, didn't show anything, so I didn't think it was relevant.
She says that at one point, but then she explains, I totally forgot about it. I
But she forgot about it later, but her initial determination, at the point, let's just say, at one point,
Right.
when she can make a decision whether or not this is covered by Brady, and she has an obligation, a constitutional obligation to turn this over, she's looked at and she decides, I don't have to.
Your Honors, you have to remember that the time code on the video is 25 minutes fast. So if she was looking at what she believed to be...
Well, I'm not disputing with you whether or not she may genuinely believe this is not going to help the defense, but but she's got something, as Judge Garcia has already pointed out, that shows the scene. It does show, and it is, I agree with you, perhaps not the best quality when one looks at this particular
terrible quality.
exhibit.
Right.
Judge Feynman has already pointed out there might have been ways to improve that quality, but putting that aside, it is the crime scene. There are some aspects of what these people's movements. There's someone standing over someone else who has fallen, supposedly the victim, and then someone running in an opposite direction.
But it is not improper for a prosecutor to make the initial determination. In fact, Kiles v. Whitley says that clearly. It is always going to be the
Well, they're always making the
prosecutor's
initial
job.
determination because they've got, as they say, the goods. The question is
Right.
whether or not,
But here-
in this case, it was material and should have been turned over.
Right. Here, looking at the quality of the video and what showed at the time
Can I
code...
ask you this today? Under the
Yes.
current policy of your office, would this have been turned
Oh,
over?
absolutely.
Okay.
And if I can just step outside the record, the trial prosecutor
need to
was
do that.
horrified when she realized that she had forgotten about this. But that's exactly why we're in front of this court, is because mistakes through inadvertence, not bad faith, but inadvertence get made. And in this case, the mistake was not material because not just of the 3 corroborating witnesses, that it's stronger than a witness, say, the two eyewitnesses to the shooting itself. You have one who knew the defendant and one who didn't. It is stronger than 2 stranger IDs because they could both be mistaken. And it's stronger than 2 witnesses who both knew the defendant because they could have a motive
We've
to
already
lie.
recognized the perils of stranger ID,
Yes.
especially in something like a shooting, under the emotional reaction that one might have to observing such a thing and the fear that it engenders. And it is a very brief and a profile. So there are problems also with this that we have recognized in the past, and the science backs that up.
Right. Absolutely. And if it were just Miss Coretta Bazemore, it would be a much weaker case. But we have Rayshawn Cream, who is a friend of defendants, who has no demonstrable motive to lie. His testimony at trial, which was unimpeached, was, "I did not get a deal for my testimony," and he was already incarcerated and serving his prison sentence at the time he testifies at trial. He could not be hoping to get a further benefit. And you have Mr. Courtney, who doesn't see defendant just strolling back and forth. He sees him running back, tucking something in his waistband, and there was video showing the defendant running back down the street towards his apartment, one arm sort of out to the side and swinging, and the other one held in close to his waist. So you have strong corroborative evidence here.
Thank you, Ms. Ross.
Oh,
Thank you very
you're
much.
welcome, Your Honor.
Ms. Hull?
Very briefly, actually, I just want to pick up on the prosecutor's reference to the second video that they actually put into evidence. They comment a lot about the quality of the suppressed video. The video that they put in, you don't see anyone's face. They say based on its time and place, it's the defendant. We are saying that based on the time and place of this video, it's the shooting. That's why it's material. And I just want to quickly clarify one thing about the summation. There is a subsequent statement that the prosecutor makes towards the end when she's referring to the lobby. She goes, Ms. Davis only says it's in the lobby. It's common sense, and there's some brackets in my thing. It's common sense that you wouldn't be able to see into the street, the sidewalk where the shooting occurred. Now, that's not true. That's why we're here. So that's why we have highlighted that summation misconduct for what it is. It wasn't an inference, or it was quite clear. It paralleled the very
What's the
video.
response to your adversary's last point, that Cream really has no motive to fabricate? Which makes the case stronger on the people's side.
But even under the circumstances that he came forward were suspicious enough to give rise to a question of whether he had a motive to fabricate.
Well, if you think there's a possibility that he may have been the shooter or involved in the shooter, isn't that a motive to fabricate?
Absolutely.
And doesn't the video go to that?
Yes. So, I mean, the point is that all of this could have been, this opened up the case. This opened up a defense that otherwise wasn't available. If the court has no further questions.
Thank you, counsel.
Thank you very much.